Hey everyone, Andrew Esquire here from the Legal Mindset coming to you on the Chrystul Kizer case. This case has been highly requested because it just so happens to be out of Kenosha, of all places in the United States. Kenosha, Wisconsin has been the center of these controversial cases, and they both, well, at least a bit, imply self-defense. We had people outside the courtroom, outside when Kyle Rittenhouse was found not guilty, when he was acquitted because he acted in self-defense. They were saying, the activists were saying, if Kyle is acquitted, if Kyle is not guilty, so is Chrystul Kizer. Chrystul Kizer has to be let off if Rittenhouse is let off. Well, today I'm going to expose the fact that, hey, that is an absolute lie. It is not true that Chrystul Kizer has to be let off if Kyle Rittenhouse has to be let off. However, this is a very interesting case, and there are a lot of facts that could lead to Chrystul Kizer getting off. We're going to break it down. We're going to separate the feelings, the propaganda from the facts, and actually explain in a succinct, neat way the Chrystul Kizer case. So, guys, this is where we need to start. We need to start with the facts. What happened with Chrystul Kizer? Because the facts are what's important, and the facts of every case need to be separated out. You can't just say, hey, the law sort of seems like kind of the Rittenhouse law. Let's look at that. No, let's look at the facts. Well, Chrystul Kizer was allegedly, and these are all allegations, they need to be proven at trial, but let's take them at face value just for the purpose of this video. Chrystul Kizer was sex trafficked, right? She was sex trafficked by an individual, a man, a guy who was doing a lot of bad things with a lot of underage African-American girls, right? He was taking video of them. He was performing sex acts with them. Now, these things will need to be proven at court. They will need to introduce video evidence, other testimony, other documentary evidence, police evidence to show that, hey, this trafficking was going on in the past. For years, this was going on. And Chrystul Kizer, it appears, based on her behaviors, based on everything we know about this guy, based on what we know the police have, she was probably trafficked by this guy. Here's the issue. The issue is that she ended up killing him not while she was being trafficked, but after, right? And that's the real issue. So it wasn't during the acts, right, or during the time in which she was actively being trafficked, i.e., it wasn't in the moment she was locked in a cage and she broke out, or she was locked in a house and she broke out and she had to kill him to get away. No, it appears, based on the facts, that Chrystul Kizer went over to his house knowingly with a gun, right? As he was sitting there in his house in a chair, shot him, right? And then proceeded to burn his body and the whole house down. So she essentially killed him, premeditated, came over in her car, shot him, burned his house down, and left. And she also posted about it on social media, right? She posted a shot of herself in his house saying, my mug shot. She also posted a few days later that she would do it again. She would just openly do it again, right? So those facts are much different than Kyle Rittenhouse. This is not something happening at a riot. This is not something happening in response to somebody else having a gun pointed at you like Gage Grosskreutz did, right? So these facts are totally different. However, we need to look at these facts and what they have and how the law applies. This is not actually self-defense law. The real key turn here is the human trafficking statute. And this actually was a major legal contention. So what happened was, at the trial court level, the lowest level, the trial court judge had said that there is a provision in the human trafficking statute that allows you absolute immunity, but that did not apply in this case. And they took that up to the appeals court, and the appeals court said, no, in fact, it can't apply. So let's look at that statute. Let's go ahead and share. I'm going to share this, guys, with you, and we're going to look at the actual statute, the actual thing that is at issue here in this case. Now, the issue with this, the large issue, the bigger issue, is that if we go ahead and if we adopt this, which is this statute here, the human trafficking statute 940.302, by the way, Wisconsin's statute site is in such demand, it is getting so many hits that it is still down, guys, because of the Rittenhouse case, because of this case. The demand on that website is so big, it is still down. I still was only able to pull this up in the middle of the night here in Korea. But now that it is day in the United States, I no longer can pull up the website. So it seems like as soon as people wake up, they're going to the Wisconsin statutes and crashing the damn site. Insane, right? But here's the statute. 940.302, it defines human trafficking. And at the bottom, it has an affirmative defense, right? So it's defining what the elements of trafficking are. And let's just read this. Trafficking means recruiting, enticing, harboring, transporting, providing, or obtaining an individual without consent of the individual or attempting to do so. So if the individual, for example, consents to go along, that's not trafficking, right? That's an agreement. If you say, I'm going to go with you, or this is my job, we have a written agreement, that's an agreement. That's not trafficking, right? Commercial sex act means a sexual contact for anything of value which is promised or given indirectly or directly of any person, right? Services being activity performed by one person at the request, under supervision, or for the benefit of another person. So human trafficking, a person is guilty of a Class D felony if he or she knowingly engages in trafficking for the purpose of labor or services or a commercial sex act, and the trafficking is done through any one of the following: causing or threatening bodily harm, causing or threatening financial harm, restraining or threatening to restrain any individual, violating or threatening to violate law, destroying, concealing, or possessing any passport, right? Debt, bondage, any of these things, right? They can be guilty. Now, at the bottom, this is what applies in the Chrystul Kizer case. And this is what we're really going to look at, because if he was guilty, there's proof at trial that there's video showing him in the past, let's say, having her do sex acts, right? Holding her hostage, right? Physically threatening her, threatening bodily harm, financial harm to her, that would fall under the statute. That would fall under human trafficking, right? If you're threatening somebody with bodily harm, if they don't do a sex act, that's trafficking, right? That's straight up trafficking. So that would apply, right? No ifs, ands, or buts. Here's the thing. The affirmative defense: a victim of human trafficking has an affirmative defense for any crime he or she committed as a direct result of trafficking, without regard to whether anyone was prosecuted or convicted for trafficking. So you don't need to prove that they were guilty of trafficking, right? Which is insanely broad, right? Which is insanely broad. So you can just say, okay, I'm a victim, and we don't need to prove that they're guilty. I'm just going to claim that and be able to assert this self-defense. Well, this is kind of weird. How do you apply this, right? Who has the burden of proof when? This is really ambiguous. And the problem is the ambiguity of this affirmative defense. Who has the burden of proof to prove that they're a victim of human trafficking? In my mind, what you would have to do is you would have to place the burden, in this case, on Chrystul Kizer to prove that she was a victim of sexual trafficking, of human trafficking, right? Once she proves that she was a victim of human trafficking, then the burden would shift to the prosecution, right? And there would be an absolute defense implied, and they would have to prove, hey, this doesn't apply in this case for one reason or another, right? But it really turns on, is this human trafficking? Because she went over, let's have no doubt, if someone, and this needs to be proven at trial, but if she came over, shot him in cold blood, right, and burned him, burnt his house down, and there was no threat, no intimidation, right? There was no active bodily harm going on at the time, then maybe that's a little too attenuated. Maybe that's too far away. The issue in the Chrystul Kizer case is that the threats, those bodily harm or physical harm or financial harm, that may have happened in the past. So let's say, for example, let's give another example, right? Let's say that there's somebody who is human trafficked, and they're trafficked as a very young person, maybe 18, 19 years old, right? Well, all of a sudden they're 40 years old and they're really mad about it. And they find the person, they are able to locate the person that trafficked them. And they go over there and they torture them and they kill them, right? They do heinous things to them, right? And it's a vengeance thing. And now I know some people out there say these people are getting what they deserve. And look, from a moral, ethical standpoint, we can have that debate. I'm here to entertain that debate. But we're talking about the law and how you apply the law. Do we want vigilantism where people are going out there and getting back at people that harm them? I'm thinking of Sin City here. If you guys have seen that movie, getting back at people that harmed you in the past, right? People that did nasty things to you in the past. Now, that is exactly the case, right? That is exactly the case that I think we don't want to have in America. We don't want people taking justice in their own hands. That was the pushback against Rittenhouse. People called him a vigilante. People said, we don't want self-appointed vigilantes. So, doesn't it apply to every political side and every issue, right? Shouldn't we be consistent if we don't want vigilantes? Now, Kyle wasn't a vigilante. He wasn't going out there trying to start a fight, right? In this case, Chrystul may have actively thought about this and actively gone out to perform this action. Now, what do we need to see at trial? We need to see whether or not this guy, this man, threatened her actively at the time. Let's say he sent her a text message that said, hey, I'm going to freaking, do bad things to you. I'm going to hurt you if you don't come and do these sex acts, if you don't come and do these illegal activities, right? If you don't come over here and work for me, come over here and do this again. I'm going to threaten you. I'm coming to find you, right? If that was proven, then maybe it's immediate, right? But what I don't think we can have, what I don't think the law can have, is people coming after people years later, months later, even, weeks later, right? If the threat is removed, it needs to be immediate, right? That needs to be a standard, because that defense is a crazy broad defense. Think about how wide that could get, guys. We could have people whose maybe their girlfriends are alleging that, hey, there's sex trafficking going on, and does that justify them to go and kill them, to black widow their husbands? Or their boyfriends or whatever, people they're having relations with? It's a slippery slope. And the problem with the law is it's precedent, not just for one case, but for many cases. And look, I have to admit, Chrystul Kizer is an extremely sympathetic case. It's a case in which I would believe jury nullification could be absolutely legit. Let's say, for example, that under the law, they're not able to prove that Chrystul Kizer had an immediate physical threat. Maybe she had no threat. Right now, Chrystul is saying that she was attacked when she came over to his house. However, the evidence may not show that. So let's assume that the evidence doesn't show that. Let's say the evidence shows that she walked in the door, kicked down the door, came in. He's sitting in a rocking chair, whatever. He's sitting in a chair, blasts him twice in the head, burns his corpse, burns the house down. Right? Let's say that's what it says. Right? Those are the facts. Now, those may be proven wrong at trial, but let's just assume this for a second. So in that case, reasonable interpretation of law could say that the human trafficking affirmative defense does not apply. She was not actively being threatened, not actively being trafficked. She was trafficked in the past, but that's no longer an affirmative defense. However, the jury could hear this and say, look, this guy was a piece of shit. He was scum, right? He was absolute scum. He did nasty things, not just to Chrystul, but to other women. And you know what? We agree with the morals behind this, even if we don't agree with the law. Well, then you've got a good case for jury nullification, right? Now, the lawyers can't argue that, but the jury could just say, yeah, you know what? We're not charging her, we're acquitting her, right? Because they can't force them to vote in a particular way. You can't force a jury to vote in a particular way. And that's one case where I would say, look, if that's what the evidence shows, let's go with jury nullification, right? I mean, but we have to be honest about the law. And on my channel, in the Legal Mindset, we're always going to analyze things with honesty towards the law. Rule of law, precedent, they're very important. And in this case, we have methods to get Chrystul Kizer free. If that's what we want, let's get her free. But let's not sugarcoat it. Let's look at the law the way the law should be applied, because it's never applied just to one case, but to many. And that was the whole issue with Rittenhouse. If we want to make a comparison, the whole issue with Rittenhouse is it was going to be applied to all self-defense cases. So there would be essentially no more right of self-defense. Self-defense would be gone, at least in Wisconsin, right? Completely abrogated, because I don't know what situation will be self-defense if it is not applied in Rittenhouse's case. Now, with Chrystul Kizer, we can say this is a sympathetic defendant. This is somebody who we sympathize with. In that case, with sympathetic defendants, this is a star case for jury nullification, but not necessarily for application of an affirmative defense, right? So, guys, this is a little bit complicated, but I hope you've been able to follow. If you're interested in me following this case, really tracking it as it goes through, please leave a like, please leave a comment. If you agree with me, leave a comment. If you disagree, leave a comment. I enjoy other perspectives. I enjoy people agreeing and disagreeing. And I know this is a case because it is so politically charged that people are going to agree and disagree with me on. Guys, you can also find me on my legalmindset.locals.com, which is my community where I post all my uncensored, unfiltered scripts. If you think this was unfiltered, check out my locals. You'll be pleasantly surprised. Take care, guys. Until next time.